Good afternoon, everyone. We're back on the docket for the afternoon docket, and we're going to begin with our first appearance docket. I just want to let everyone know that today's not your trial, so don't talk about your case because everything in this courtroom is being recorded and can be used against you at a later time. Just please consult with your attorney before you speak on the record. We're going to start with Kendall McClover.
All right, thanks.
He's approaching, Judge. Is your name?
All right, Mr. McClover, you're before the court for count 1, domestic battery by strangulation, and count 2 is touch or strike battery, and I do find probable cause, and I'll hear from your attorneys, as to bond.
Your Honor, I would be requesting a $7,500 bond on count 1 and a $1,500 bond on count 2. Order of no victim contact.
Okay.
One moment, Judge. Judge, I'm going to be asking for the court to consider reducing the bond a little bit. I'm going to be asking for a $5,000 bond on count 1 and a $1,000 bond on count 2, making it a total of $6,000. The reason why I'm asking for that, Judge, is my understanding is Mr. McClover has a clean record. He is a registered voter here in Broward County. I did advise him as far as with all domestic situations, the court's going to impose a no contact order. He will abide by that order. Judge, he's 32 years old and living here his whole entire life. He graduated from McFadden Technical, where he's now employed in the same field. I'm just asking, because this is his first contact, because he has a clean record, and he has strong ties to the community, that's why I'm asking for a total of $6,000 on his behalf.
Does Mr. McClover have priors?
I saw no history, Judge.
All right. So if I'm probable cause as to count 1, a bond is $5,000. As to count 2, it's $1,000. No victim contact, sir, until further order of the court.
Now, Judge, he understands that no victim contact. All of his belongings are at their residence. Can he go back one time with law enforcement to recover his property?
One time with law enforcement to recover his property, yes. Jonathan Sanchez.
He's approaching, Judge.
Mr. Sanchez, you're before the court. Count 1, domestic battery by strangulation. Count 2, touch or strike battery. I do find probable cause.
Your Honor, I'd be requesting a $10,000 bond on count 1, a $2,500 bond on count 2. This is based on the allegations, but also Mr. Sanchez's criminal history. 2012 theft, 2011 strong-arm robbery with a violation of probation, 2010 violation of a domestic violence injunction with the violation of probation, and in 2010 he was arrested for a domestic violence battery. That charge was dropped. The domestic violence cases in 2010 were against a different alleged victim.
Okay.
Judge, I understand Mr. Sanchez has a record, but I believe he's been clean and has been basically trouble-free for a couple of years now. He's 31 years old. He's been living here his whole entire life. He's working for a company called Picture Perfect Pressure Cleaning, where he's been working there for a number of years. Financially, that's a problem. He's not going to be able to afford the $12,500, which the state is suggesting. We're going to be requesting on count 1 a $3,500 bond, and on count 2 a $1,000 bond. Now, he does have family that lives in our community, specifically his brother, who also works for a pressure cleaning company. He believes that his brother may be able to afford the bond, if Your Honor were so inclined to set it at about $4,500.
All right, I do find probable cause. As to count 1, his bond is $10,000, and count 2 will be $1,000. No victim contact. Jomar Amos.
Mr. Amos, come on up, please.
Mr. Amos, you're before the court. Count 1 is robbery by sudden snatching without a firearm. Count 2 is touch or strike battery.
Your Honor, I'm going to be requesting a $2,500 bond on count 1 and count 2, order of no victim contact with Shana Elisa Prince. Just noting, victim had to be brought to the hospital to receive treatment for swelling and tenderness to the side of her head as a result of the incident. Mr. Amos, in December of last year, pled out to 3 separate counts of petty theft.
Okay.
Judge, and that's what Mr. Amos was telling me is he has nothing similar to this in his past. Right now he is working. He works at Subway, where he's been employed there for now 2 months, making $8.45 an hour. He lives separately from the victim. He's actually living in Lauderhill with his uncle, and that's who he's going to be reaching out to post his monetary bond. His uncle is a security guard, so he doesn't believe that he can afford that. What I was going to be asking, Judge, is for the court to consider setting a $2,000 bond on 1 and a $1,000 bond on 2 for a total of $3,000 on Mr. Amos' behalf.
All right, based on the allegations, I do find probable cause, and I'm going to impose a bond, $2,500 on each count. No victim contact. Kenneth Douglas.
He's approaching, Judge. Bless you.
Mr. Douglas, you're before the court. Count 1 is aggravated battery. The victim is pregnant. And count 2 is felony violation of probation. That's a no bond hold. I do find probable cause.
Your Honor, I'm going to be requesting a $7,500 bond on count 1, order of no victim contact based on the allegations. Considering at this time he is on probation out of another state and does have a lengthy history in Broward, fraudulent application for driver's license, possession controlled substance, aggravated fleeing and eluding, see a previous arrest for aggravated assault with intent and felony battery, great bodily harm. Those charges were dropped. Also has felony drug priors in the past for delivery of cocaine. Nothing further.
Judge, considering on count 2 specifically as a no bond hold and it's out of state, at this time nothing to request from the defense.
All right. As to count 1, the bond is $7,500 and no victim contact. Good luck, sir. Shakari Timms?
All right.
Yes.
All right, Ms. Timms, you have an out-of-state felony hold. You will be before the extradition court Tuesday or Thursday of next week.
Do you know what state it is?
Georgia.
Georgia?
Yes.
Okay. And do you know what the charge is supposed to be? No, they just tell you.
Right.
It's out of state hold.
Yeah.
Okay.
All right.
All right.
Oscar Artiega. Sorry. Yeah. Mr. Artiega, you're before the court for there's an out-of-state felony hold out of the state of New Jersey. It is a no bond hold, and you will be going before the extradition court next Tuesday or Thursday. Good luck, sir. Jamie Kirsten.
North Broward, Your Honor.
All right. Ms. Hairston, you're before the court for 1 count of trespassing, occupied structure, or conveyance. I do find probable cause, and I'll hear from your attorneys.
Your Honor, I'm going to be requesting a $1,000 bond, pretrial release with a GPS monitor, no return. I provided the court with the pack, and I showed Mr. Reedy, and you can see how, and this has been going on for years, frankly. I spoke with Mr. Gooden this afternoon, who's the homeowner of her ex-husband that she keeps trespassing. She just got out of custody, resolving a violation of probation March 19th before Judge Brown. She was on probation for 2 separate trespasses at Mr. Gooden's home. Her violation was based on another trespass at his home. While those cases were pending, she was initially sent to Judge Lerner Wren in mental health. Judge Lerner Wren released her to reside with her parents on a GPS monitor. I provided the court with a copy of the violation of pretrial. She continuously, over and over and over again, goes to her ex-husband's home. It predates those 2 cases. I provided the court with the probable cause affidavits from at least 4 arrests for going to her ex-husband's home. When I spoke to him, he advised me, you just have the cases where he has called the police. There's been many times where he hasn't called the police. He told me prior to this incident, earlier that same day, she let herself into his home when he was in the middle of a business with a client. Your Honor, you can see in this report that she advised law enforcement that she went there because she needed a place to sleep. That's not true. She has her family here. She has her parents. She can live with her parents. As you can see from Judge Lerner Wren's order, she was ordered to stay with her parents. And I know that there are issues with Ms. Hairston, and I sympathize with that. But at the same time, Mr. Gooden's following the law also. And he has a right to not only enjoy his home, but not have anyone in his home that he doesn't want in his home. And thankfully, nothing really bad has happened so far. My concern is if this situation is allowed to continue, something bad could happen.
Well, Judge, I can tell you that there's no way Ms. Hairston's going to be able to post a $10,000 bond. I don't even think she can post the $100 bond that's currently set. I know she wants to resolve it, and I'm not so sure that that's likely to happen here this afternoon. There are other issues here other than trespassing, and maybe sending her back to Lerner Wren would not be a bad idea.
I need rehab.
I know you do, Jamie. And, you know, Judge Lerner Wren has a lot of the resources that could, I know.
And
what
I'm
are you going to
sorry,
do? You can't lock her up forever.
I'm not suggesting that. I'm suggesting, but we're at first appearance, and we're hearing the same story we've heard every other time. And it's at one point, and I'm sorry, I have to go to it. Fool me once. Shame on you. But how many times is the court going to be asked to accept her explanation that it won't happen again? She just needs some treatment. This man he's the one that has to keep dealing with her, letting herself into his home.
Was the case before Judge Lerner Wren, that was resolved and that's so done and over with?
Yes, but Judge Lerner Wren transferred her out of mental health to Judge Brown.
To Judge Brown. I see that.
That's why she was put on probation by Judge Brown.
All right, Ms. Hairston, I don't know what's going on here, and there may be other things that you need to discuss with your attorney, but at this time, I am going to impose a bond of $1,000. No victim contact, but you've heard that several times, so I'm saying it again. And if you're able to post your bond, you are going to be on a level 2 GPS. All right, good luck, man. Christopher Sherfield.
He's approaching, Judge.
Mr. Sherfield, you're before the court. Count 1 is possession of cannabis 20 grams or less. Counts 2, 3 through 4 are a civil writ with civil purge amounts attached to them, and then counts 5, 6, 7, and 8 are out-of-county misdemeanor holds. Looks like those are out of Monroe County. So I do find probable cause. All the other...
Judge, oh, I'm sorry.
Go ahead.
Judge, just being Mr. Sherfield, we did go over basically counts 2 through 8 that unfortunately this court can't do anything about. These are basically, I believe, out of county holds, as you said, all misdemeanor from Monroe. He did advise me that their open case is not violation of probations. So having said, Judge, on count 1, he does wish to see if the state is willing to resolve the cannabis offense.
Offer to be a withhold, court costs.
1 moment. He wishes to accept the state's offer, Judge.
Okay. All right. Mr. Sherfield, please raise your right hand. As best as you can. Do you swear or affirm to tell the truth?
Yes, ma'am.
All right. You can put your hand down, sir. Mr. Sherfield, do you understand everything that's going on here today?
Yes, ma'am.
All right. And just so you know, the writs are out of... Oh, no, they are all out of Monroe County, looks like. All right. So we're resolving count 1, which is a possession of cannabis 20 grams or less. Do you understand that?
Yes, ma'am.
Do you need more time to speak with your attorney?
Yes.
What? Oh, he's standing right next to you, so...
Thank you, Judge, for giving me that opportunity to speak, Mr. Sherfield. I do not believe he has any further questions, but the court may inquire.
All right, sir, you need any more time to speak with your attorney?
No, ma'am.
Is anyone forcing you to resolve your case today?
No, ma'am.
Have you ever been treated for a mental or emotional illness?
No, ma'am.
And you understand that you have the right to go to trial, but by taking a plea today, you're giving up that right?
Yes, ma'am.
And do you understand that if you're not a U.S. citizen, by taking a plea, it could subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter?
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given, and your sentence, sir, is a withhold adjudication and court costs. Good luck.
Good luck, sir.
Juan Perez.
He bonded, Judge.
All right.
Mr. Simpson.
And then Quasi Simpson.
He's approaching, Judge.
Mr. Simpson, you're before the court for 1 count of trespassing. I do find probable cause.
Judge, in speaking Mr. Simpson, he wishes to ask the court if the court will consider resolving this matter today.
1 moment, Your Honor.
Okay.
Okay, the offer will be time served, but it's very likely to be the last time served offer for a trespass in this area at a first appearance, at least from the state, just so he understands.
He wants to accept the state's offer.
All right, Mr. Simpson, please raise your right hand. As best you can. Do you swear or affirm to tell the truth?
Yes.
Okay, you can put your hand down, sir. Do you understand everything that's going on here today, sir?
Yes, ma'am.
And do you need more time to speak with your attorney?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you understand that you have the right to go to trial? By taking a plea today, you are giving up that right.
Yes.
And have you ever been treated for mental or emotional illness?
No.
And do you understand that if you're not a U.S. citizen, by taking a plea, it could subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter, Mr. Simpson?
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given, and your sentence serves adjudication and time served. Good luck.
Okay.
How about Terrence Holland?
Mr. Holland, come on up, please.
Mr. Holland, you're before the court for burglary, unoccupied conveyance, unarmed. I do find probable cause, and I'll hear from your attorneys.
Yes. Thank you. The state would be requesting a $2,500 bond and no victim contact. His criminal history includes 2012 delivery of cocaine, 07 possession of cocaine with intent, 15-month state prison, strong arm robbery 05, 17 months state prison, felony battery due to priors and possession of firearm by convicted felon 05, 17-month state prison. Those are his most significant priors, Judge.
Okay.
Judge, at this time, it's being Mr. Holland, that's recent.
All right. I'll impose a $2,500 bond. Good luck, sir. Stephen Folks.
Please approach the judge.
Mr. Folks, you're before the court for count 1, false ID given to a law enforcement officer. Count 2 is an out-of-state felony hold. That's a no bond hold for the state of Georgia. I do find probable cause. You will be before the extradition court Tuesday or Thursday of next week. And your bond on count 1 is $100.
Judge, and speaking of Mr. Folks, he advised me that on count 2, the out-of-state hold is in reference to a new law offense. It's not a violation of probation. He did advise me that on count 1, the misdemeanor offense, he wishes to resolve that matter. I did advise him at this time, I could not advise him one way or another how it would affect his case in Georgia. It would go down on his criminal history score sheet, but other than that, I made him no other representation as far as how it will not affect his case in Georgia. But he wants me to ask court if the court would consider resolving count 1 and see if the state has a plea offer for him.
Yeah, the offer would be time served as long as he understands everything that Mr. Romero advised him of and everything I imagine that Your Honor will advise him of.
Mr. Folks, do you understand what Mr. Ramirez explained to you? So
Not 100%.
right. So we don't know what's going on in Georgia. We don't know if it's true that when it occurred. So if you don't understand, I'm not gonna make any changes today. I'll just leave it. No bond on count 2 and $100 on count 1.
Thank you, Judge.
Freddie Vasquez.
Please approach the judge.
Mr. Vasquez, you're before the court. Count 1 is DUI, alcohol or drugs. Count 2, refusing to submit to DUI tests. Count 3 is violating a restriction placed on your driver's license. Count 4, possession of open container. 5, improper right turn. 6, disobeying traffic device. 7, improper stop. 6, unlawful speed. Counts 5, 6, 7, and 8 are traffic infractions not for magistrate. So I do find probable cause, and I'll hear from your attorney.
Your Honor, I was going to be requesting a $5,000 bond on count 1, a $500 bond on count 2, pretrial release with no alcohol or intoxicants and random testing.
Judge, Inspector Vasquez, he's 41 years old, been living here in South Florida for the past 16 years. He is receiving disability. He lives in Oakland Park by himself. His monthly rent is $870, so basically at the end of the month, he really has no leftover money to live, just to basically go grocery shopping, and that's it. He advised me there's no one that can post his monetary bond. At this time, Judge, we're going to be asking for the court to release Mr. Vasquez on pretrial release. If the court feels that standard pretrial release is not secure enough for Mr. Vasquez, then we wouldn't object in the court imposing a level 2. But there's no one that's going to be able to post his bond, Judge.
Do we have a driving record for Mr. Vasquez? This is third, well, is this correct, that this is his third offense within 10 years?
Yes, Your Honor, I checked the dates that the arresting officer put down in the report are accurate.
Okay.
And I believe, Judge, and correct me if I'm wrong, I believe it was 4 years ago, the last DUI offense.
All right, I'm going to release Mr. Vasquez to pretrial supervision. He's going to be on a level 2 GPS with random testing, no drugs or alcohol.
Thank you for that, Judge. The only other request I'm going to ask you is for a phone order. He knows the information as far as the landlord, but he doesn't have their phone number, so I'm imagining pretrial has to verify his address, so that he wants to be able to give the phone number to pretrial of his landlord so they can verify his address.
Okay. I'm only laughing because, you know, every day we hear this, and I wish I could stand out on the street side and say, memorize somebody's number in case you get in trouble. All right, I'll sign the order. All right, on our hearing docket, on the felony hearing docket, we have Johnny Dixon.
County, Your Honor.
Thank you.
It's coming up.
All right, Mr. Dixon is before the court for a 30-day motion. He was arrested on March 1st.
Yes, Judge. State has not filed an information. He's entitled to an ROR in this charge. I see he still has a VOP hold, but we'll have to take care of that in front of his assigned judge.
He has a VOP hold.
Yes.
Yes, Judge, I think actually there's 3 of them.
There's actually what, Mr. Reedy?
It's 3 separate cases he was on probation for. but-
Okay. All right. So, do we want to proceed with this 30-day motion?
Mr. Dixon, if the court grants your motion, you'll be released on this charge, but you'll still be in custody on the violations of probation.
Right.
What that means is that you won't be getting credit for time served on this case, because technically you'll be out of jail on this case. If you ask me not to proceed on the motion, you'll continue to get time served on it.
No, I'm not going to ask you that.
Okay, that's fine. Then we'll ask for the ROR, Your Honor.
All right, I'll sign the order. Good
Okay,
luck, sir.
good luck, Mr. Dixon.
All right.
Just weird to see.
Durrell Akins.
North Broward, Your Honor.
All right. What's the status of Mr. Good afternoon, Mr. Akins.
Good afternoon, Your Honor.
Has the information been filed on Mr. Akins?
Your Honor, the state did file an information.
All right, Mr. Akins, you were brought before the court for a 30-day motion. The state has informed me that they have formally filed the charges, so there's no action for me to take today. Okay?
Oh, okay. I didn't receive no indictment. I didn't get indicted, though. I didn't get indicted.
Well, there's an information filed. Mr. Linder, when was the information filed on Mr. Akins' case?
Today, Your Honor.
They filed the information today, so you will be getting the information soon. Bryce Levine?
Hold on.
Oh. All right, Mr. Levine, also, March 1st. Has the information been filed?
Yes, Your Honor, and information was filed yesterday.
Yesterday? All right, Mr. Levine, you are brought down for a 30-day motion for release. However, the state tells me that they filed the information yesterday, so there's no action for me to take today, okay?
Okay, thank you very much.
All right, sir. Albert Bavard. Oh, it's North Broward.
No problem.
Mr. Bavard also, well, he was arrested on March 30th. So he's here for a second look on his bond status.
Yes, ma'am. He's being held on a $1,000 bond for tampering with evidence. I'm going to ask that the court keep that bond in place based on Mr. Bavard's history. From a 2018 case, he was sentenced to 348 days in county jail on a violation of domestic violence injunction and resisting without violence. He just pled that case out and was released January 23rd of this year. Unlawful use of false name ID 2017, violation of injunction 2017. 2014, burglary of a dwelling with a battery, aggravated battery, shooting at or throwing a deadly missile, burglary of a structure, resisting without violence. He was qualified as a habitual offender in that matter. 2005, attempted burglary of a dwelling, grand theft, tampering with a witness or victim, sentenced to 8 years state prison as a habitual offender and a PRR offender. Again in 05, attempted burglary of a dwelling, attempted strong-arm robbery. He received the same sentence while being qualified HO and PRR. Battery 05, possession of cocaine 03, attempted robbery with a weapon in 99, 44-month state prison, attempted burglary of a dwelling 98, 44-month state prison, and an escape in 1998, 44-month state prison.
All right.
Well, in speaking with Mr. Brevard, Your Honor, he's not able to make that bond. He has been a resident of South Florida all of his life. He has a place to stay, but he can't afford that $1,000 bond. I was going to call his mom to see if his mom could bond him out, but from what he tells me, that's probably not going to happen. He's spoken with his mom; she just doesn't have the money to do it. So he can't make the $1,000 bond as it's currently set.
This is a second look at the bond. It's not a 30-day motion, so I'm going to deny the ROR at this time. Who else do we? David Key. Sorry.
Come on up, Mr. Key.
All right, Mr. Key's back for a second look on his bond status. Mr. Key has $1,025 in bonds.
Judge, and speaking of Mr. Key, there's nobody going to be able to afford to post his monetary bond now. He does live local. Lives locally here in Tamarack with his niece. My understanding is Mr. Key is also working at this time. He works at at a business called In and Out Tires, where he's been employed there for 9 years. He's 57 years old. My understanding is he's been basically without trouble with the law over 20 years, Judge. Considering this is a nonviolent offense, I'm going to be asking the court to consider releasing Mr. Key on, first to consider ROR. If not, then on pretrial release.
I just reviewed his criminal history with pretrial. His criminal history report out of the state of Georgia, frankly, is 17 pages. His last run-in with the law in Georgia was a probation violation 6 years ago.
Okay, I'm gonna deny the ROR at this time.
Judge, one other thing I just want to point out to the court. My understanding in reviewing the PC affidavit, I believe first the encounter with law enforcement led from a traffic-related matter. At that time, law enforcement asked Mr. Key for his permission and consent to search him. Mr. Key cooperated, gave him permission, took off his socks, and that's where they found the drug. I just asked, based on his cooperation with law enforcement, and this is a drug offense, Judge. I'm gonna ask the court to reconsider placing him on pretrial release for that reason, not my previous reason.
All right, I'm gonna deny that. Elaine Zaltzman.
He's approaching, Judge.
Mr. Zaltzman was arrested on March 30th. He's here for a second look on his bond status. He's got a total bond of $1,000.
Judge, he can't afford to post his bond.
Well, Your Honor, I've been advised this appears this is a grand theft auto where he stole his father's car. That's what I was advised, Your Honor. His father was in court over the weekend. He has no ties to the community. He has 3 pending cases out of New Jersey this year alone. I think it says something, you know, his father's aware of the situation and is electing not to bond him out after he stole his vehicle. Stole it out of New Jersey and brought it all the way down to Florida.
Okay. All right, I'm going to deny the ROR at this time. Lonnie Haynes.
Mr. Haynes, come on up, please.
Yes. Well, I can look at Broward and get an idea.
All right, Mr. Haynes was arrested on March 30th. He's here for a second look at his bond status. He has a grand theft pending charge with a $1,000 bond.
Judge, we're going to be asking for the court to consider releasing Mr. Haynes on pretrial release. My understanding, Judge, this was at a Target, I believe. From what the PC affidavit said, him and his co-defendant took merchandise which was located in a backpack with the value of $296.95, and what made it, I guess, over the threshold of $300 to make it a felony offense was, I guess, additional, merchandise discovered on the person of the co-defendant. Judge, right now, Mr. Haynes, from what he advised me, he's working. He works for a moving company. That job is still available to him. He lives in Lauderdale Lakes. He has a place to live. He lives with his parents. I'm going to be asking the court to consider releasing Mr. Haynes on pretrial release. One other thing I do want to point out, Judge, and speaking with Mr. Haynes, is he was stopped by the loss prevention officer. If he wanted to, he could have run. He didn't run. He walked with them voluntarily. So, Judge, I'm asking for pretrial release on Mr. Haynes' behalf.
I don't believe Mr. Haynes is a good candidate for pretrial. He was just released from state prison. Was it December? November. Sorry. That was, he was sentenced to 51-month state prison in 2015. Additional prior, 2013, 14 months in state prison for felony theft and grand theft. Felony theft in 09, 3-year state prison. Felony theft 09, grand theft auto 07, 19.5-month state prison. Burglary of a conveyance and theft 06, a year and a day state prison. Felony theft 06, a year and a day. Grand theft 05, a year and a day state prison. Theft 04, theft 03. Robbery with a firearm or deadly weapon 91, 7-year state prison.
Motion for RR will be denied at this time. Meister Joseph.
North Broward.
North Broward, Your Honor.
All right.
How you doing, Your Honor?
I'm doing well. How about you?
Could be better. I'm ready to go.
I hear you. Ms. Joseph has been in custody since March 30th.
Yes, ma'am.
She's before the court for a second look.
Yes, Judge, I'm going to ask the court to consider pretrial release from Ms. Joseph. She is unable to post the bond that is currently set. It's a grand theft. I think the total amount of value is a little over $300. And she's been in 5 days. She has no one to post her bond.
Concern. First, I see she's had multiple failures to appear in the past.
That's true.
Okay. Can I have one moment, Your Honor? Michelle, can I ask you?
Miss Speak?
Yeah.
Hold on a moment, Ms. Joseph.
Yeah, I just need your, if I could just show you something, I need your input. You could understand this better than I can.
And also, while you're thinking about what you're going to say, make sure you're not going to be talking about your case.
Okay.
And Your Honor, just so to explain to the court, there's also been a previous violation of pretrial. That was in 2017. I'm just trying to understand the wording of the warrant, so I asked Ms. Worrell if she could take a look. And,
Okay.
it looks like it had something to do with the GPS monitor. You understand what I'm saying, right?
Have a seat or stay in cell.
All right. Ms. Joseph, I'm going to deny the motion for ROR at this time. All right, good luck, ma'am. Let's go to the...
Brian, did you talk to George Brown?
Matt,
Talk to George Brown?
Yes?
Speak, Your Honor.
I wouldn't say anything at this point. The reason the motion is denied, and no small reason, Ms. Joseph, is because they say you cut your previous monitor off, so, you know, it doesn't leave me a lot of room to work with. You'll be in front of your division judge soon.
All right.
Which was taken care of through Judge Porth.
Okay, let's not talk about this. So when you go to your division, you can resolve your case there. George Brown.
I still.
He's here, main judge.
All right, Mr. Brown was arrested on March 28th.
This is second look on a false
He's on a
ID.
second look.
Correct.
Hector, what is he?
Judge, my understanding is when he came in, he had a violation of probation. I believe he resolved that violation of probation. I believe his release date on that is April 16th, 2019.
Okay.
Having said that, normally I would be probably advising Mr. Brown if he wanted to, and not if he didn't want to contest these allegations. We could be requesting maybe the court would be willing to extend a plea offer. But from what speaking to Mr. Brown, he has a Duval hold, and he believes the Duval hold is relating to some sort of violation of probation. If it is, I'm not comfortable, and I would advise him to resolve this case. So I would be asking for an ROR.
Do we know that he has a Duval? It is confirmed.
I mean,
I don't know what it's for.
I mean, yeah. The question, and I'm just thinking aloud here, is whether he was found in violation of his Broward probation, and how that might be held against him in Duval. But that's for another day.
Yeah, you know, with these things, when we're all saying we don't know, you know, I'm not going to take any action today. Let's just leave it, and he can figure it out. And once you have it figured out, you'll probably have a better handle as to your attorney will be better able to explain to you what to do, and you'll better understand what's going on in the different counties before you try and resolve this at first appearance. Okay?
Yes, ma'am.
All right. Cedric Jean-Pierre.
Conti, Your Honor.
Okay.
Your Honor.
All right, Mr. Jean-Pierre is also in for a second look. He was arrested on March 30th. He has a $100 bond on a paraphernalia. Is there something else holding Mr. Jean-Pierre in custody?
Not as far as I can tell, Judge. Are you interested in resolving this today, Mr. Jean-Pierre?
No.
All right. Can you make bond?
No, I really can't. My family got no money like that.
Get a place to stay?
My cousin's house, but I don't know if he's gonna let me stay. So I'm gonna see what's up.
Well.
All right. His bond is $100. We'll leave it at that for now. All right. Good luck, sir.
Yeah, I know.
All right, everyone. I think that's it. Okay.